Ladies, gentlemen, good afternoon, and welcome to today's MIABC event. It has been approximately 8 months since many of us have had to pack up our offices to work from home. Though we have been slowly reopening many shops and services, and some of us have returned to the office, we are still very mindful of our duties to act reasonably and behave prudently to limit the spread of COVID-19. The MIABC is delighted to maintain its ongoing tradition of providing you with timely and insightful presentations on topics that we hope you will find both useful and interesting. We are also very honored that you have decided to spend the next hour with us for the presentation today, and hope that you will also stick around for our Mingler sessions afterward. The links were provided in the webinar email. As a networking group, this year has proven to be very challenging to maintain the same type of events as in prior years. However, the MIABC Board of Directors have been hard at work developing new ways in which we can all engage with each other. Please stay tuned as we hope to have more details in the coming weeks. Now, to start our presentation on super priority liens, I would like to introduce our panels. First up is Noah Sarna, partner, Thorsteinssons LLP. Noah is a partner practicing in the firm's Toronto and Vancouver offices. Noah's practice focuses on all aspects of community tax, including goods and services tax, harmonized sales tax, provincial sales taxes, and property or land transfer taxes, including Vancouver's vacancy and empty homes taxes, BC's foreign buyers tax and speculation tax, and not at least Ontario's non-resident speculation tax. Prior to joining Thorsteinssons, Noah practiced corporate, commercial, and real estate law at a large regional firm. He has written a series of books and articles on various issues in those and other legal areas. Next, Tim Lack, partner, Bridgehouse Law LLP. Tim Lack is a founding partner at Bridgehouse Law LLP and has been the responsible lawyer for over 10,000 real estate transactions, acting for banks, credit unions, and many other institutional and private lenders. His work with private lenders is extensive, and he has been asked to provide numerous expert opinions on private lending issues for litigation lawyers. He has lectured on several occasions to other lawyers on the subject of private lending and protecting the priority of secondary lenders. Next, Amanda Magee, Director of Business Development, Western Canada, Stewart Title. Amanda Magee joined Stewart Title in 2004 and has worked in title insurance for 15 years, having been responsible for both the operational and marketing portfolios for Western Canada. She is a licensed professional with the BC Insurance Council and proudly hosts memberships with the Canadian Risk Management Association, the Insurance Institute of Canada, and the Mortgage Investment.
Andy, I think your mic's gone. Tim?
Yeah, it sounds like Andy's off mic, so I think we're going to take it away with the panel discussion in any event.
We're going to go
here. Okay. Well, thank you very much, Andy, for those kind introductions for the three of us. And I was laughing when you introduced Noah, because for job security, Noah's probably the only person in Canada who wants more taxes. When you're listing all the taxes, I don't know, Noah. Anyway, here we are talking about mortgages and priority, and of course, this concept of GST super priority. Mortgages, as we know, have been around, you only have to go back to the Bible or Charles Dickens to read about, the debtors and being thrown in prison for not honoring your obligations. But mortgages, as we know them, have been around from about the 15th century, and nowadays here in Canada, it's been defined pretty much by our courts to say that a mortgage, security is what a mortgagee wants. In most cases, he would not lend money to the mortgagor without security. That's from the 1980s Alberta case, but that defines our mortgages in a nutshell. We're lending money. Most of our audience out here today are bankers, brokers, or lawyers or other service providers to that industry. We lend money. We expect security. We want that security in a certain priority position. We want to know that our security is there, our priority is there, and we can recover. And then boom, here we are today talking about someone who's going to jump in unbeknownst to us. And when I say us, I'm talking about the lending profession, whether you're a banker or a service provider. And we jump forward to the year 2006, 2007, where a contractor has a GST obligation, and then the bank lends money, and they thought they were in a nice, safe position, and they weren't. Now, Noah's going to march us through some of the facts of that case, but it's interesting to note that Noah's going to talk about the Court of Appeal, the Federal Court of Appeal decision. But if you go back to 2018, when the Federal Court of Canada came out with its decision, lawyers were expecting it to be overturned. I went back and read some of the material about the initial decision, and lawyers were saying it'll ultimately be overturned. Well, Noah's going to tell us that it wasn't. And for all kinds of technical reasons and policy decisions, people expected it to be overturned because they expected lenders to have some certainty in their lending transactions. And that's what we're really focusing on today. How all of a sudden with a decision from 2020, many of us are concerned about the certainty of our lending, of our loans. And on that note, I'm going to hand it over to Noah to walk us through this, I'll call it an ugly decision, but some of you may call it something different. Noah.
Oh, no.
Uh-oh.
No sound on Noah.
Noah.
You want to try turning your mic on and off? No, we'll just troubleshoot it. No. My recommendation, Noah, might be to quit the session and rejoin with a fresh link. Like, just rejoin the link. Okay.
Okay.
So Noah's left. We're going to try and bring Noah back on.
Noah's going to try and jump right back on. And in the meantime, so we're going to focus on a decision where TD Bank lent money to a landscape contractor. And they set up a power line, equity line, whatever you want to call it, thinking that they were in a nice, safe position. And they took a mortgage on the fellow's personal residence, and he was a sole proprietor. So that's a little bit of the background. I don't know if Noah's going to get us in deeper with the facts.
No sound.
Noah, are you there yet?
What a shame.
Okay, well then I'm going to keep marching away because we've got a big audience today. I think we're close to 80 to 100 attendees. So what did TD come back at? TD said, well, we're going to fight this on 4 fronts. We're going to first say that, we took the mortgage on his personal assets.
Hey.
Oh,
can you hear me? Oh, awesome. Sorry about that. I promise I'm way better at my job than my laptop. Okay. I prepared slides for today, and I'll speed them up just because I know we already ate into a few minutes of my time. Does the audience have access to the PowerPoint presentation I created? I assume. Sorry?
I believe they do.
They do. Awesome. Okay. So I'm not going to share my screen. So this
No,
is
if you in the taskbar on your right hand side, if you click on slides at the bottom there, the little slideshow, and you click on that, you should see your PowerPoint presentation right there.
I don't see it, but I don't think it's a problem.
Okay.
Oh, there it is. Awesome. Okay, I'm going to go quickly through it in let's say 8 minutes.
Sounds good.
As Tim lined up very, very nicely, the content of my discussion right now is the Federal Court of Appeals decision in TD v. Canada. Now, I'm going to quickly move. Let's see if I can control the slides. Amazing. The goal of my presentation in the next 8 minutes is to describe what the heck. This is infuriating. And for someone who wouldn't have the particular tax knowledge that underlies this decision, it's shocking and crazy. So it's critical for all you guys to understand what it's about, and then through the course of this discussion, what could be done about it. So I'm going to quickly talk about the CRA's collection powers, what is a prescribed security interest, a wonky tax term, but I'll explain it in practical detail. I'm going to talk about the previous cases on super priority, which is the focus of this case. Quickly, the facts, arguments, and reasons in the TD decision. And then, as commonly as asked, can a comfort letter help? So very quickly, as you're probably all aware, when you're dealing with not all tax debts, but specifically GST and source deduction debt that has been assessed, so the CRA sends out a tax bill, the CRA can move to collect through various powers. There's a whole bunch of things, but really the most common ones are garnishment orders. So lenders probably receive these sorts of things saying, under statute, you can't pay the tax debtor, you've got to pay the CRA, and there's also liens. But even before there's an assessment issue, so even without an audit or a tax bill being received by the borrower, by the debtor, the law on GST establishes what's called a deemed trust. So very quickly, trusts usually involve something in writing saying, I am holding this property in trust for someone else, for a beneficiary. A deemed trust is created by law. It says that even though there's nothing like that going on, you as a deemed trustee have got to hold this property for someone else, in this case for the government. And the GST law also establishes not just the deemed trust, but super priority that pushes the CRA ahead of the line, above other creditors, secured creditors, with the exception of someone that holds a prescribed security interest. We'll get to that in a sec. But the basic idea with super priority is that the lender, which is commonly the case, has got to send the funds to the CRA as the holder of that super priority, as the beneficiary of the deemed trust. So forgive me if it's a bit wonky. Just very quickly, this is a common question that comes up when we talk about this stuff. The main exception to the super priority rule is for someone that holds a prescribed security interest. And in a nutshell, that involves a mortgage registered before the collection of an amount of GST that ultimately is not remitted. So if you register your mortgage before, for instance, someone starts up a sole proprietorship for which they ultimately become non-compliant for GST purposes, if you predate the mortgage, the act of having collected the tax, then essentially you're golden. Now, there's an extremely technical wrinkle on that, which I've tried to explain in the slides, but I'm not going to really talk about it. But that's the basic idea, that if you got kind of a very simple mortgage arrangement that predates the GST having been collected, then that should be outside of the super priority rule. As a lender, you're just essentially safe. As a practical matter, the CRA doesn't really deal much with the details of those wrinkles, that reduction I described. So as a practical matter, usually it's not a concern, but technically it certainly is if you've got any of the financing arrangements that appear there. Okay, moving on. There were a bunch of cases on super priority before this one. So to me, before this decision was released, it has some uniqueness to it, which I can get into at a later point. But really, when you're dealing with source deductions especially, there is a history of case law that essentially affirm this point, that would have led me to assume that in this case, the outcome would have been as it is, crazy and dumb from a lender's perspective, but still relatively sound in law. I just wanted to add, so there is this history, the Federal Court of Appeal has ruled on it. There has been an appeal filed to the Supreme Court, but we don't yet know, to my knowledge, whether or not the Supreme Court has agreed to hear the decision. So we'll have to see how that turns out. Again, I'm pessimistic that even if they hear it, which I don't know if they will, because they take very few tax cases or cases of this nature, but if they do hear it, I'm pessimistic that we'll get a more favorable decision than we got here from the Federal Court of Appeal. Now, I know Tim went over some of the facts here. I'm just going to reiterate, partly because I wasn't in the room when that happened. So the borrower here, Weisflock, had a landscaping business as a sole proprietorship. So the whole issue here doesn't involve, for instance, a company that was running a business where the borrower was an individual, a shareholder director. Here, everything happened legally within the person himself. There was no separate legal entity involved. In 2007, 2008, there was $86,000 of GST debt, which I recall from the facts just means that there was a landscaping business, charged tax. Instead of sending the tax to the government, kept it himself, essentially. In 2010, Weisflock took a line of credit with TD, secured it against his home. Again, he was the owner of the home. TD, and I don't know the details here, was unaware of the tax problem. It could have been that there was fraud or something of that nature. It could have been that there was some sort of dispute with the CRA about whether tax was actually collected. We don't really know the details. Then in 2011, Weisflock sold the home, repaid the line of credit, and then the CRA sued TD for the $68,000 repaid by Weisflock upon the sale, essentially saying, look, there was a deemed trust over these proceeds that you received. Rather than pocketing it, TD, you should have sent it to the CRA under these rules. So again, very quickly, the main arguments and reasons here, TD argued first that there must have been some sort of triggering event to crystallize the deemed trust. Taking that out of legal speak, they really said, there's got to be something to perfect the government's interest here. Some sort of claim or registration or filing, something additional should have been done under the law. The Federal Court of Appeal, rightly in my view, said, no, that's not part of the rules here. They don't need to do anything specifically. All the law says is that there is a deemed trust over the property of the debtor, of the tax debtor, or the proceeds of sale of the property of the debtor. Then TD argued that there was something akin to what legally, again, is called a bona fide purchaser for value. TD, as is common sense in this scenario, thought, well, look we lent money to you, you paid it back to us, we had no knowledge of the tax debt, we're not in on any kind of conspiracy, we are innocent, we should not suffer because of this. And the court essentially said, I don't care. That's not what the law takes into account. And I kind of explained a bit more of it here, but that's the basic idea. They said, look, there's policy reasons why the Crown, the government has super priority here. Doesn't matter that you were innocent. That's not what we care about. Lastly, so after this decision came out in 2018, it shocked a whole bunch of folks. And again, it's a little unique in a few ways, but I can get to that later. But a lot of people started asking whether a comfort letter can help. More specifically, just unpack that a bit, the government offers comfort letters. So letters essentially saying, look, to whoever's asking, we confirm that this particular person doesn't owe tax at this point in time. They thought, well, maybe we can get that before we forward funds to someone, a borrower we potentially have concerns about. My experience has been that they usually take a while to arrive from the government. And then even once they do, they often say subject to audit. And which means that, they only provide so much benefit if you can get them with enough breathing space before the loan needs to be financed. So that's it. I turn it over to Amanda. Tim. Okay, there you go.
So excellent. We don't have any questions, but I mean, my question basically was, so the courts basically said, and CRA said, TD, you should have paid us our portion of this GST arrears, even if you didn't know about it.
Right. The most relevant part of this, going back to what I mentioned about a prescribed security interest, the exclusion there, is that the tax debt came into being. The GST was collected by Weisflock before TD registered its mortgage on his home. And so because of that, even though there was the point in time thing and TD was unaware, the court said we don't really care. CRA is still a super priority.
So from a practical standpoint, Tim, how, what does this mean for your work?
I'm going to get to that because I wish I had a really slam dunk answer for you, Amanda, but I'm just going to recap very quickly the failures in the arguments presented by the lawyers for TD Bank in this case. Noah mentioned that they tried to assert that the bank was a bona fide purchaser for value. Again, the courts have held in other situations where a secured lender, or a lender for that matter, is not a purchaser. I've seen it before in other cases not involving priority. The deemed trust required a triggering event. That was another argument raised by the TD Bank lawyers. But as we heard, and as the case points out, the trust is created as soon as the GST is collected and not remitted. And then there was the argument also raised that the GST arose out of the business of the individual, and the bank had lent money on the personal assets. I don't know if it'd be any different, but it was a sole proprietorship. So there's that commingling of the flesh and blood individual as business person and as homeowner. So that argument didn't fly either. Now, many of you in the audience are lenders and bankers, and must still be shaking their head. And Noah, voiced the outrage and the concerns here, because there is the policy argument that this creates uncertainty for lenders, and there's a negative impact on commercial transactions and secured lending. The interveners in this case, and interveners are those parties that are allowed by the courts to present argument because they have a vested interest in the outcome. There was a bank, I think it's the Canadian Bankers Association was the intervener in this case. So you guys were well represented. It just didn't go your way. In their view, and this was the main argument of the Canadian Bankers Association, was that the decision of the federal court creates unacceptable uncertainty for secured lenders, which will have a material adverse impact on commercial transactions and secured lending. The policy argument didn't work. It didn't fly, and the appeal court went with the previous decision. So Amanda,
yeah,
you asked, what should lenders be doing? Well, it was almost trite at the end of the decision that Noah went over. Was the court set out, well, there's avenues for lenders, and the court said, well, identify your higher risk borrowers. For example, a sole proprietorship.
Yeah.
Guys, ladies, I'm sure you all know which are going to be your higher risk borrowers. The court said maybe get enhanced disclosure, including but not limited to requiring borrowers to give evidence of tax compliance. I'm sure your underwriting team does their very best to get a snapshot of that client prior to lending as to their tax compliance. So the court isn't saying anything new. And that would be for a sophisticated lender. I'm thinking also there are a large group of lenders out there whose business model is pure equity lending.
Mm-hmm.
And their marketing point is, we do it fast.
Yeah.
So that underwriting basically comes down to an appraisal and not much else. The courts went further. They said, require the borrower to provide an authorization to CRA, allowing the lenders to make inquiries regarding outstanding tax liabilities. You're probably familiar with the form. It's not this, you can't use a generic form. CRA wants to see it in their standardized form that allows you to make inquiries of CRA as a lender on the borrower. Noah, have you seen any pushback from CRA ever when a lender asserts that authority or tries to use that authority?
No.
No, you haven't. Good. Well, there's a plus. So
Right.
add that CRA form. I'm sure no one knows the exact form by its number off heart. In your package that you get the borrowers to sign, and then they throw something in like review your lending practices. So then I went back and said, okay, what have bankers, tax lawyers, underwriters, what have they put together to help their clients wade through this GST super priority? And Noah talked about the prescribed security interest, which is effectively a mortgage that is registered prior to the GST liability arising. Now, Noah, you mentioned that there's 2 scale backs on that. And I think we should focus just a little bit on that. So you register a mortgage for $500, but over the course of the loan being out there and unpaid, CRA asserts that $500,000 can be clawed back under certain circumstances. Noah touched on 2 of them. One was that you continue to make the lender continues to make loans to the borrower after the GST liability arises, and the other one is whether or not there's other forms of security available attaching to other assets with other values. And I also think that it also is clawed back by any payments made by the borrower to the lender after the GST liability arises. So that might be a big one too. Asking your clients to provide ongoing evidence of remittances. Great. More work for all of you out there. More work for your backroom people. More work for your underwriters. More work for managing the file after you've funded and after you've registered. Getting a comfort letter prior to discharging. Noah's already told us about the shortfalls in a comfort letter. A comfort letter, it might give you some comfort, but it's not the be-all and end-all that this person has no GST liability. The next one is a compliance, a certificate of a clearance certificate. Forgive me, is that right? So Noah, that's the ultimate.
Right. Yeah, I don't know exactly when they provide clearance certificates. I don't know if they provide them in this specific setting or whether comfort letters are I thought clearance certificates were kind of for other more specific scenarios. I wasn't sure that they do that with these kinds of circumstances.
Okay. I know lenders have changed their mortgage terms, requiring evidence of compliance prior to delivering a discharge. And I've got pushback. When I'm acting for a lender and I insert that in my mortgage terms, that's when the phone starts ringing, because I do get pushback, because every borrower is concerned that they're going to want to pay you out in a hurry and they're going to lose financing if they have to wait for CRA's evidence of compliance. So I do get pushback a lot. And on the borrower side of things, when I've had a lender pull that on me, the lender actually used that because he was getting it was a vendor-backed mortgage, and he was getting a nasty rate of interest. So I just pulled out the Business Practices and Consumer Protection Act and said, I owe you this, I'm going to deliver this, and I expect a discharge. And I got my discharge. I don't think my borrower client had a GST liability, but the other lawyer, he was stuck between his terms where he said, I wanted evidence of GST compliance, versus me saying, I've got an act that says if I pay you out, a provincial act I might add, if I pay you out, you're delivering a discharge. So the other fellow backed down. But again, that may have been because he was just trying to eke out as long and as hard of a period of high interest as he could, versus someone who has a bona fide concern that there's a GST liability out there. Some lawyers have gone so far and so bold as to say, well, why don't we have the borrower post a cash security until a clearance certificate is obtained? And I'm using the word clearance certificate, even though Noah and I both are 100% sure if that's the correct CRA terminology. Nevertheless, evidence of compliance, okay? Posting a cash security, is that practical? Are your borrowers in a position to post security until they provide that evidence to you? My guess is no. Perhaps extra guarantees, because the concern is, and with the TD case as we saw, you deliver a discharge, you go on your merry way, and this comes back to bite you. What was it, a year, 2 years, whatever the case may be? You think you're out of the deal. You delivered a discharge. So I don't know, a continuing guarantee from someone, and perhaps someone you can track down, and perhaps someone with security. And then I guess hoping that your lending and your documentation and your security fits the definition of what Noah was talking about, the prescribed security interest. Ideally, I guess that's the one way you're going to be able to assert a priority for a mortgage over GST, subject to the exceptions that we talked about, namely that you're not making advances after the GST obligation arises, that there isn't some form of alternative security with value that can claw back on your amount that you're asserting, and that they haven't been making payments to you with money that has been part of that deemed trust. And then the courts also mentioned that this super priority loses its super priority if your borrower / debtor goes into bankruptcy, which as a lender you could petition your debtor into, or perhaps your borrower voluntarily seeks the protection of the Companies Creditors Arrangement Act. The courts have held that at that stage, that GST becomes effectively an unsecured creditor. So, but petitioning a debtor into bankruptcy is work on your part. Seeking the protection of the Companies Creditors Arrangement Act is not a simple procedure for a debtor. They may not want to do it, and even if they want to do it, it's an onerous task. So, Amanda, you asked what a lender should do. I've just marched through 7 or 8 of them. None of them are easy. None of them are foolproof. Some of them are time consuming. Although I have seen CRA turn around these comfort letters within 3-4 weeks, which is nice. But I'm still concerned about those lenders who don't have a team of underwriters, those lenders who don't have the ability to follow up with the borrowers, or forgive me for saying so, the sophistication to follow up with borrowers and ask the right questions, or the equity lenders, where their business model is not to worry about the unsecured creditors and only worry about what's the place worth, what's the value of my loan, I'll fund you by Friday. That is my concern for those types of lenders, that they're not asking for any type of compliance up front, let alone down the road, let alone down at the time of discharge.
And I think Noah made a good point too about the TD case. I mean, in this case, it was a landscaper, who had his own business. But what about in this day and age with the gig economy, right? We have a lot of applicants for residential mortgages that have full-time jobs and that are applying with their their pay stubs and their T4s. You know, does anybody ask, is it common to ask, do you have a separate side gig going on? Are you running a separate landscaping business? Or is your wife running an internet business, you know, out of the garage or whatever? So I think you're right. The lender due diligence is varied across the board when it comes to people's degrees of self-employment.
For the commercial lenders, you're dealing with a lot of self-employed individuals. To the equity lenders, you're dealing with people who don't like filing taxes or can't show you their T4s. And then, of course, we're talking about the BC and specifically perhaps the Vancouver market generally, where we have the type of borrower who doesn't have the GM job, necessarily the government job, or necessarily the T4 job where he can produce those NOAs and the T4s with quite readily.
Question to Stewart Title. It's a good one. So if it's okay with you, Tim, I'll throw my slide deck up here. And
I was too busy talking to slide through my slides in any event.
Not a worry. If it's okay, I'd like to, if you'll humor me, just firstly summarize what we've learned so far from Noah and Tim and put it in the context, you know, of title insurance and the changes that have come out of the private sector in our industry as a way to mitigate or transfer some of these risks. So what have we learned? We've learned so far that government entities can claim super priority liens or deemed trust over the assets of a borrower who has collected but failed to remit certain types of taxes and certain types of deductions. And we've learned that legislation allows CRA to collect these debts directly from the lender. We've learned that these debts are generally GST, employee income tax withholdings, EI premiums, and CPP. And we also know that these types of liens that the lender is liable for are not typically registered on title. They take priority over the bank or the private lender's mortgages. And as the TD case demonstrated, they can extend this lender's liability for up to 10 years, and they can do so even after the mortgage has been discharged and security has been released. So what about title insurance? To understand how title insurance companies have responded, it's important as a foundation to firstly understand what coverage is already available as a baseline within your standard title insurance policy. All title insurance policies in Canada for both residential and commercial properties will typically cover both for institutional or private lenders, losses that are caused by super priority liens for debts that are owing to CRA at the time the loan is funded, of course, provided that the bank isn't aware of them. And I've got a graphic to demonstrate some of the timelines there. So these are debts to CRA that are already in existence at the time that you fund your loan, that you don't know about, but have power to take priority over your mortgage after you fund. So the good news is this coverage is generally already automatically included and typically falls under covered risks within the policy that are associated with priority. This protection stays in effect for as long as the policy is in place, and that's really critical, as you'll see later, to understand. The term of a title insurance policy ends when the mortgage is discharged. So if you are already currently title insuring your loans, the coverage is available for both institutional and private lenders. It's not new, it's quite robust, so I hope that those of you that are on the call today can take some comfort in that. And certainly at Stewart, we have experienced a steady stream of these types of claims of this nature for several years now. So this is an example of what we're talking about here. And this would be a standard example of how title insurance would typically provide coverage for a CRA claim, where the debt to CRA, the GST debt in this case, arises before the mortgage is registered, your mortgage is registered, and the CRA claim is initiated. Note here that the debt arose prior to the mortgage and that the mortgage has not been discharged. This is a typical claim. This would be an example of the opposite, what's not covered. So note in this instance that the borrower has stopped paying GST after the loan is granted. This lender may have some protection afforded to it under the prescribed security interest that Noah mentioned, but not under a title insurance policy. So when it comes to title insurance policies, we're talking about debts that arise prior to the mortgage, not for losses that are created after the loan policy is issued. So that's a standard policy. What changed with the TD case was that the mortgage and the title insurance policy that protected its priority were long extinguished, right? The security had been discharged, the mortgage had been paid out, the policy had lapsed. So there was a real demand for a solution after this case was decided to address this sort of, I guess, newly brought to light risk that was always there, but has just been more in light lately. And essentially what it is it's a post-discharge liability. It's a post-discharge risk. So on August 24th of this year, we launched a 10-year post-discharge super priority lien endorsement. And what it does is it extends the ability for lenders to submit a claim under their prior coverage for super priority liens post-discharge of the mortgage. So it's an endorsement. An endorsement is sometimes called a rider. It's an add-on to insurance, and endorsements are typically used where you need to expand the standard coverage to address a specific risk, like earthquake or fine art collections, or this new risk that we've identified. It's a way for lenders who are concerned about the TD case and liabilities that extend for this period beyond the discharge to protect themselves, and to provide comfort to shareholders, members, boards, and obviously enterprise risk committees. The coverage can also assist to make pools of mortgages that are being securitized more valuable to prospective investors or buyers that may be concerned about these ongoing CRA liabilities that extend beyond the life of the mortgage. So in this example here, this is essentially the TD case, right? The debt was in existence at the time the mortgage was registered, and then the mortgage was paid out and discharged, and then later the CRA claim came. And so in this example, title insurance would only be provided and provide protection via this new post-discharge endorsement. So try to make it just a little bit more simple there. So in a nutshell, the post-discharge endorsement essentially extends the already available coverage for super priority liens for a period of 10 years post-discharge. It's currently appended and it's included automatically for all institutional loans and residential properties. For transactions involving commercial properties, or if you have residential properties with more than 6 units, which are typically considered commercial, it's available upon request for both institutional and private lenders for a nominal premium. So if you're a bank or a credit union and you're already mandating title insurance, this endorsement is now being issued automatically. You've got that protection as of August 24th for all institutional residential loans. For commercial properties, like I said, it's available for all lenders, institutional and private, for an additional premium. So if you're a commercial lender or you're acting for a commercial lender and you're wanting this 10-year protection, you will want to amend your commitments and your mortgage instructions to include a request for title insurance with a super priority lien endorsement from your provider. So there's the coverage that's available within the private sector, in addition to the new coverage to address some of the risks that we see now post-discharge. Obviously, many of you are aware that we have a great team here in BC. So if you'd like to learn more about this, I encourage you to reach out to any one of us. I wanted to thank my fellow panelists at Bridgehouse Law and Thorsteinssons. I also wanted to acknowledge the MIABC and the members who supported us. It was a really collaborative effort to craft this coverage. It's the first of its kind in Canada, and we're consistently amazed by the innovation and the resiliency of the real estate lawyers and the real estate legal community that we have here. And I'm very grateful for industry associations so that we could continue to create stuff in the spirit of a collaboration. So thanks to all of those involved that brought this issue to light. There's a few questions I thought maybe as a group we can take a look and see.
I'm going to make one quick point. There has been suggestions that if this had not been a sale, or when you're faced with a situation where you're getting paid out not because of a sale, but rather because of a refinance, that's money coming in not from a disposition of an asset, but rather new lender's money, and that may not be subject to this GST super priority if that's how you're getting paid out with a refinance. So some tax lawyers, I believe, out of Toronto have suggested that a refinance is probably not going to be something that is going to lose out to a GST super priority charge. I also thought about always these arguments that people say it takes too long to get these CRA comfort letters. It takes too long to hear back from CRA. Perhaps we should be changing our loan documents. Everybody has the clause that says it's due on sale, but perhaps there should be more proactive clauses that when a borrower lists a property, he has to give notification to a lender. In that case, you get your notification and you go back to your borrower and say, time to get busy, time to start calling your accountant to get that comfort letter out of CRA. Because when you do get your sale and they march through their subject removal period, I want to know that that's not the point we're starting. When I get a request for a payout, that's not the day I want to start asking CRA questions. I want to start asking CRA questions the day you list.
It's a good point, Tim. Just looking at some questions here. There's one for me. For the post-discharge coverage to be valid, does the title insurer require the lender to show they made any efforts to confirm the tax status prior to funding? The short answer is no. We don't require any tax investigation to be done. On the flip side, I would proceed with caution, because if you do undertake to do some tax investigation and it does turn out that your client, the borrower, does have tax liabilities, that then would become a known matter, which may actually negate the coverage available under the policy. It sounds like, so Vince writes, it sounds like we still have liability over GST that arises after we register our mortgage, with the exception, I guess, of the prescribed security interests. So for example, if we lend against 10 unsold new condos and they sell 6 of them to pay us out, the GST liability created by the sale will not be covered by this policy. Am I mistaken on that?
I guess I don't quite understand. If you register the mortgage before the liability, then why
prescribed security interest would apply?
Right. Yeah. Why would you be outside? So I think it might be mistaken, unless there's a wrinkle there that isn't coming through.
So there's title insurance protection for the period of debts that are owing before the mortgage is granted. There's prescribed security interest protection available for GST for the period of time that the mortgage is in existence. And then for some types of loans, there's post-policy and post-discharge protection available for debts that arise prior. So it's a little choppy for sure, but it's there's definitely some ways to mitigate this risk as a lender. Joanne wants to know if we will launch post-policy coverage for private residential transactions or non-commercial deals. Certainly something that we're looking at, Joanne, but I don't foresee it coming anytime soon in the industry, primarily because of the risk profile. But it is available for private lenders and private mix on commercial transactions. Brett's asking Noah, are there any BC provincial taxes that have the ability to form super priority? So outside of these employee remittance taxes that we discussed and GST, are there any other types of BC provincial taxes that have the ability to form this type of lien?
Right, so I should know the answer to that question, but I don't. I just recall that there are, for example, for PST, there is a deemed trust rule. So kind of the first half of what appears for GST that I discussed, but I don't recall there being super priority. So great question. Sorry.
So we'll follow up with you on that and maybe see if we can circulate that info to the membership. I'm just scrolling down here to see if there's any other questions. Otherwise, we're coming up right on time here, guys.
Can you guys hear me?
Welcome back, Andy.
Thank you for the presentation.
Thanks for having us.
I apologize for the technical difficulties. Tim, always great and a pleasure to see you. Noah, it was good to meet you. And Amanda, again, always great to see you. And on behalf of the MIABC, thank you once again for joining us for today's presentation on super priority liens. And as I would like to say, please join us for our minglers, which will be open up after this session, where you can network with your fellow industry colleagues. Once again, everybody, thank you very much.